Well, hello, and thank you for joining me today for Avoiding Accidental Disinheritance. Hi, my name is Lynn St. Louis, and I'm an estate planning and elder law attorney at ELG Estate Planning. We serve clients in Eastern Washington and in Western Washington and North Idaho as well. What we're talking about today are the laws of Washington State and how they impact someone, their estate, after they have passed away. So, as you may know, estate planning is something that I'm very passionate about. Why is that? Because estate planning allows you to plan for the future, to put a plan in place to protect yourself, your decision-making, your assets, and your family. And frankly, it is one of the greatest gifts that you can give to your family. Without an estate plan, your wishes will not be heard. The people you want to protect will not be protected. So that's what we're going to be talking about today. If you have questions, just go ahead and put them in the chat. I will try to answer them before we're finished today. So let's go ahead and let's talk about accidental disinheritance and how to avoid it. What is that? What am I talking about? So let's say you don't have a will in place, or you don't have a revocable living trust in place, and you pass on. Where do your assets go? Who gets them? And are they going to be inherited by those people that you want to inherit them, not just upon your death, but if you're married, upon the death of your surviving spouse? Then where do your assets go? And people are surprised to say, they think, oh, I don't have an estate plan. And so they might think, oh, everything goes to the state of Washington. That's a very rare result. It does happen. We'll talk about it, but it's rare. Oh, I'm married. Everything goes to my spouse. Well, maybe, maybe not. So we're going to get into details. I think it's really helpful if I can share with you examples and stories so that you can see how not having a will, not having an estate plan will impact you. And if you've heard me before, you know that I often talk about having in place durable powers of attorney for finances, for health, your healthcare directive, also known as your living will. We're not going to be spending time talking about that, but I would be remiss if I didn't mention that is also an essential part of an estate plan. And if you don't have it, you are not going to like the results that you get if you should lose capacity, because the state will step in. Now, I'm not talking about the state as being this big, bad, awful thing. I'm just saying that the state's rules and what the state's plan for you might not be what you want to have in place. So in Washington, if you don't have a will, you die intestate, Latin for meaning without a will. The laws of intestacy are RCW 11.04.015. I'm just going to share my screen really quick to show you that. That is the statute on descent and distribution of real and personal property. If you want to take a look at it, try to figure it out, feel free to do so. I'm going to be sharing with you how it impacts you. So let's start with the simplest situation possible, and that is you are a single person. If you are a single person, what that statute says is where your assets go when you die if you haven't indicated where they go. So how does the whole process work? Well, there's going to be a probate because you haven't given direction to your assets, and you haven't set up a revocable living trust, or you don't have a will. If you have a will, there'll be a probate, but the probate is way easier when you do have a will, because you will have named, excuse me, who the executor is, who gets what. But you haven't done that. So we are dealing with Washington State's laws of intestacy. And what that means is who gets what. Now, if you're a single person, your kids are going to inherit from you. That is what the state thinks you would want to have happen. And oftentimes that is actually the situation that you would want. So I'm going to share this little graph I have here, which is intestate succession. So if you're not married, the answer is no. You have descendants. Yes, 100% of your estate goes to your descendants. And what do I mean by descendants? That's your kids. What if one of your kids has passed? Let's say you have 2 kids and they're both alive. They will both inherit equally from you through the probate. And likely is in the probate process, one of them will have been appointed what we call personal representative. It's also known as as actually an administrator of your estate. When there's a will, it's called executor. When there's not a will, it's called administrator. That's just technical stuff. But so your 2 kids inherit equally. Okay, that's maybe what you wanted. And if one of your children doesn't survive to inherit, then their children, the deceased children, inherit that 50% share. And that might be exactly what you would have wanted. What if you don't have any kids? If you don't have any kids, then the state says, well, are your parents alive? And if your parents are alive, then your parents inherit. What if the situation is this, that in your family, you have been raised by your stepfather. You don't have a will. Mom and dad are alive, and mom is married to stepdad, and he's the person who perhaps you consider to be your father, though you still, have your biological father, and you die. Where do your assets go? And you have no kids. Well, they are going to go to your biological mom and your biological father. I need to add another fact to that stepdad never adopted you. So then it goes to these 2 people. Is that what you want? Maybe, maybe not. But that's what the laws of intestacy say will happen. Obviously, if you want a different result, see an estate planning lawyer and get a will in place to give you the result you want. Let's continue with the single person situation. Let's say you don't have kids and your mom or dad, if there's one of them that survives, they get it all. But let's say mom and dad are both gone. Now where do your assets go? Well, under the statute, it says, do your parents have any living descendants? Well, what does that mean? Really, we're talking about the siblings, your siblings, full siblings, half siblings. As long as there hasn't been an adoption, they're legally in play here. So your siblings would inherit from you. And if a sibling didn't survive, then in their place, the child of the sibling that you have would inherit their share. So all this is probably making some sense, that what the laws of intestacy look to do is distribute your property, and we're talking about a single person here, according to who is closest to you in bloodlines. Really looks at bloodlines. So if you don't have any siblings alive, then it goes to nieces and nephews. If they're not alive, then we're saying, who are your cousins? And if you have cousins or any deceased children of cousins, whatever degree that is, they inherit from you. So that's pretty much how far we go. And then at that point, let's say that you don't have any cousins or, issue of cousins, etc. Then what happens? Well, if you don't have anybody that close to you in bloodlines, does it go to the state? Not quite yet. If you have a stepchild from a deceased spouse, then your stepchild will inherit from you. And then after that, it goes to the state of Washington. So it is intended to go to the people who, from a bloodline perspective, are closest to you. And after you've exhausted all of these bloodlines, you don't even have cousins or anybody who's still alive that survives you, then it will go to your stepchild, and then it'll go to the state. So that's a single person situation. Now, keep in mind that there is no control over where your assets go. You haven't indicated who's going to be administering your estate, who's going to be the personal representative, and you haven't said that you want a trust for anybody. Maybe one of your children is disabled and they get government needs-based benefits, so they inherit from you. They will lose their benefits until they're spent down. Or let's say you have a child that you didn't want to inherit from you. So they are going to inherit equally with the other children. So I think you get my drift. What I'm saying is you have given up all control over where your assets go to the state's laws of intestacy. That is what happens with a single person situation. So in a way, a single person passing with no will is actually easier in a way, and then also more difficult in a way than when one of the two spouses passes. So let's talk about now a couple's situation. When I say a couple, I mean somebody who's married or is a registered domestic partner. If you are in a couple's situation and you're not either one of those, but you are in what we call a committed intimate relationship, then you can bet that there is going to be a lot of litigation involving who gets what. Because even if you're not married, but you've been in a situation where you've held yourself out to be like in a marriage and you don't have a will, that person who is that surviving not spouse is going to have equitable claims as if they were a spouse. Now, why does all of this matter? The reason that this matters is that when one person of one party of the couple dies, it opens up everything for investigation and determination and analysis. It makes everything so much more complicated than it ever needed to be if you had an estate plan. Think of it this way. This is how I think of it. A well thought out estate plan is like a gift to your family, a gift to your loved ones. It makes everything that was messy and tidy and makes it neat, messy and untidy, and makes it neat and tidy, like in a gift box. And sadly, when you pass, what's going to happen? Well, you open the gift box and, oh, here's what the plan says. It says everything goes here or there, or it's divided this way, or the plan's been set up to avoid probate, or if there is a probate, because there's a good reason for it, who's going to be the personal representative and who gets what without having to dig into that person's life too far. Contrast that, a nice, neat, and tidy estate planning package with no estate plan at all. It gets messy. Why does it get messy? It gets messy because when you are married, and I'm talking about Washington State, and we all know we're a community property state, is everything community property? And why do we even ask that question? Well, the reason that we ask that question is because the laws of intestacy provide different results for different characterizations of property. So I believe you are seeing my screen here that talks about, are you married? And if the answer is yes, then we go down the analysis tree. And if you have living descendants, that means your spouse gets 100% of the community property and 50% of the community property. And then your descendants get the other 50% of the separate property. So CP here means community property, SP means separate property. And then we go on and we talk about things. So why am I spending this much time talking about separate and community property? Well, obviously, it's because it gets divided differently. So community property goes to the surviving spouse. Separate property gets divided between the surviving spouse and the children of the decedent. Okay. So we have now opened a box to inquire, well, what's community property and what's separate property? And there's a lot of misunderstanding about this. Just because you live in the state of Washington and you are married doesn't mean everything you own is community property. And I'm coming from the perspective of you haven't done an estate plan. You haven't done a community property agreement. You haven't clarified what is what in terms of property. So basically, just the general rule is that whatever you acquire from having been in a marriage and either both of you work or one of you works, and then you buy your house and you pay your mortgage together, that's going to be community property. This is something from your earnings, from your joint efforts. That's community property. And remember, community property, let's say it's the house, will go 100% to the surviving spouse, which is what the state thinks that you would have wanted. And it makes a lot of sense because you don't want the surviving spouse to have to move from the marital home or sell it. But what if that house was not purchased from community funds during a marriage? But what if that house was something that was bought by one of the spouses before they got married, and their name of the deceased spouse is the only name that's on the title, and community funds weren't used to pay off a mortgage? Maybe that person bought that house with their own separate funds or an inheritance they received. Inheritances are separate property. So if that house was purchased by somebody, even during the marriage, and it was bought with separate property funds from an inheritance, that separate property, unless there are some actions to make it community. What actions might that be? That might be adding the spouse's name to the title. But if that wasn't done, or if the property was acquired before the marriage, and separate property is what was used to either purchase it or pay off any mortgage, that's separate property. Okay, so what happens then on the death of that person? It's their separate property. Where does it go? 1/2 to the surviving spouse and 1/2 to the children of the deceased spouse. You can see how problematic that would be to the surviving spouse who has just lost their husband, for example. And now what are they supposed to do? Take out a mortgage? How do they pay off the child's 50% interest in that house? Do they have to sell it? Do they have to move? It can be a terrible result. That is probably not what you intend to do to provide for your surviving spouse. If you do, make it clear in a will. Make sure that you've thought through all the implications and consequences of, if you want to give your interest in your house, only half and half, make sure you have a good, well thought out plan for how that impacts people. Of course, I'm talking about the laws of intestacy, which means you don't have a plan. You're relying on what the state statute says. So let's look at some more examples of what could happen with this community property, separate property. I think it might be helpful if I say, what else is separate property? A gift to you from somebody, like your parents give you money, either during their lifetime or via an inheritance, or they gave you property or they gave you something, that's your separate property. That's not your spouse's. Or maybe you had a personal injury settlement, came to you. That is your personal property. And I'm sorry, that is your separate property. That is not your spouse's. So when we're looking at the estate of somebody who's passed on, the law requires that there be an inventory done. And that inventory indicates what the asset is, what the value of the asset is, and is it community or separate property. It's critically important because if it is separate property, surviving spouse gets only half, child or children get the other half. So what I'm saying is that this opens up inquiry and allows for argument as to what is separate and what is real property. I mean, what is separate and what is community property, because it's not necessarily clear. I mean, it's like you got to dig up old history to figure out, how do we characterize this property? It can lead to a lot of litigation, a lot of attorney's costs, and a lot of family upset and discord because people are adversaries. And the last thing that you want in a probate process is for people to become adversaries. So I encourage you to please make sure, if you are a couple, you have a will, because just because you're married doesn't mean it's going to be easy to distribute property when the first passes. So aside from that characterization of, what is the property, let's talk about other consequences of not having a will. And let's make it an easy situation. Let's take a couple, let's say they've been married for, 40 years. And they have a long marriage, but they don't have any children together. One of them has a child from a previous relationship, and the other one has no children. And aside from this whole characterization of what is the property, let's kind of move on from that and say, okay, let's just say it's all community property. All right. So the spouse who has a child from a previous relationship dies first. Everything is community. Everything, therefore, goes to the surviving spouse, who is the step parent of the deceased spouse's child. The relationship may be good, the relationship may be bad. I don't know what the relationship is. Here is a couple that has not done any will in the past. And now the surviving spouse owns everything. What can the surviving spouse do? They can do anything they want. It's their assets. When I say they can do everything they want, they could, if they do a will, they can do a new will that says, I wish to honor what I believe my deceased spouse would have wanted, and I will make sure that on my death, through my will, that child receives whatever, half of the estate, all the estate, whatever it may be. That surviving spouse has to do a will to provide for the child of the deceased spouse. And it's up to them. They have no legal obligation to do so. Whether or not they have a moral obligation is a matter of what soul searching they do and what they know their deceased spouse would have wanted. Did that deceased spouse want to provide for his child or not? In any event, the spouse who survives must put into place an estate plan, must have a will, must give direction. Because what happens if they don't? And this is a couple who, during their lifetime together, they didn't do an estate plan. Is the surviving spouse going to now take steps to put into place an estate plan? It's probably more likely that they will, because they recognize that if they don't, where are their assets going to go? And they may or may not realize it. So in the situation I was just describing, the surviving spouse is a step parent. A step parent means that they have no children. The child of the deceased spouse is not legally theirs. And what does that mean? And in this situation, let's say the surviving spouse does not have a will or other direction of their estate plan, their assets. Where does it go? Well, a surviving spouse is now a single person, be it a widow or a widower. So as a single person, remember what we talked about, where the assets go? It goes to their children. They have no children. It goes to their parents. Their parents aren't alive. It goes to their siblings. Are their siblings alive? And if not, do the siblings leave children of their own? That is where their assets will go on their death. And again, it will go because there wasn't any estate plan in place to avoid probate. There will be a probate again. Because of no estate planning, either while the couple were both alive or through the surviving spouse, the laws of intestacy apply in both situations upon both deaths. And that child of the first spouse to die gets nothing from their parents' estate or from the step-parents' estate. So if that is what is intended, I encourage people to make it clear through a will, because if you don't make it clear, then you are left with a whole lot of unanswered questions and a whole lot of angst and upset. So this is, and you might say, well, who's at fault here? Well, let's go back to the very start. I'm an estate planning lawyer. You know I encourage you to have an estate plan in place, to make your wishes clear, to make your wishes known. Have an estate plan in place. Either have a will or a revocable living trust, and make sure you administer it correctly, because that's the problem with revocable living trusts, but make sure that your wishes are known. If you don't want to disinherit your child, in your will, say, on my death, all of the assets that I can direct, all my separate property, all my community property, either A, goes into a trust for the benefit of your spouse, and then on the surviving spouse's death, the trust says it goes down to your child. That's one option. Or else you could also say, on my death, certain assets go to my child, and other assets go to either outright to my spouse or to a trust to my spouse, and then down to my child. Just put into place some protections if you truly want to make sure that your child and your grandchildren inherit from you. You have to take action to make that happen. And if you haven't and you pass, then that is up to your spouse, whether or not they will take any actions to carry out those, what your interests may have been. And again, there's no legal obligation for them to do so. So where we usually see an accidental disinheritance is the situation where as I just described, there were no wills in place. But that is not the only place where there is accidental disinheritances. Another very, very common situation is where the couple who's married has what I call an I love you will. What does that mean? An I love you will is one of those wills that says, on my death, everything goes to my spouse. Okay. That's kind of like the laws of intestacy and everything's community property. Everything goes to the spouse. And as you know, what happens when the spouse inherits everything outright without any constraints or restrictions or directions? They can do whatever they want with it. It can then go to either under the laws of intestacy and they die and it goes to their nearest relatives who aren't your kids. Or maybe they do a will and maybe they provide for your kids, or maybe they don't. But let's say what happens is they get married again. And so now you have the surviving spouse marrying somebody new, and they again get new wills. And again, these are the I love you wills, which are wills that say, hey, surviving spouse gets everything. So what that means is this person who the first deceased spouse never met, probably, maybe they did. Anyway, they end up with everything. And what do? They do whatever they want with the assets because there's no protections or directions in the estate planning documents. So these simple wills that have no trusts in them can lead, and often do lead, to a disinheritance. And you can say, oh, I know my spouse will provide for my children, or I know that they'll take care of things. I know they know my wishes. Well, keep in mind that life changes and people's situations change and other things come into their lives and other people. And what you think and you agree would happen isn't going to happen. So I wouldn't call myself a control freak, but I will tell you, I like to see that we control things that we can control in our lives. And what we can control in our lives is the disposition of our assets. How we do that is we have a will. And if I want to make sure that my assets are going to be available for my spouse and then for my children, then I'm going to put a trust in my will that says on my death, everything goes to that trust. And it's for my spouse's benefit. And when he dies, it's going to go to my kids because that's what I want to see happen. And I'm not going to leave it up to chance. I'm going to make sure that the estate planning document says what I want it to say to avoid an unintentional or accidental disinheritance. So, any questions that anybody has about avoiding accidental disinheritance? And please feel free to put them in the chat. So the question is, what if you have put the separate funds into a joint account? Is it then community assets? That's such a good question. That can't be answered like yes or no. It has to be investigated. Was that just like an inadvertent titling of the account, or was it done with intention to make the funds community? Frankly, the easy answer most often when you see title to an asset and either certainly as husband and wife or community property or joint tenants, typically that's joint tenants with right of survivorship, is it has become community. That is typically the answer. Sometimes when we see that a couple has done that, they don't realize what they did. And so we will work with the couple to clarify, what do you consider separate property, even though you might have taken some actions that have arguably or probably made that community property. They go, oh, I didn't realize we were doing that. I had no idea. So we'll do what's called a property status agreement that says, for example, my house remains my separate property, regardless of, whatever actions, or this account remains my separate property. We, of course, would give directions to say, the title of that account, which is indicative of what the ownership is, it's not conclusive, but the titling of that account, make it consistent with what you believe it is. If it's supposed to be separate, just have it in your name. If it's supposed to be community, have it in both names and make it clear. And then you can have a document that backs up to clarify it. Next question. If I have a will and a trust from Oregon and have moved to Washington, will my will and trust be honored? Short answer is yes, it will. Any estate planning document that was valid in the state where it was executed is valid in any other state. we know that if you have a will trust valid in Oregon, it's going to be recognized as valid in Washington, California, anywhere. That kind of begs the question, though. It's not whether it is valid, is it a good idea? Is it a good idea to have that estate plan that you had in Oregon and not do a new one in Washington? And the answer is, I don't know. You'll have to take a look at what is your situation. Go see an estate planner and an elder law attorney in the new state that you moved to, because you might find that there are really good reasons not to have a revocable living trust. Not uncommonly, people who move to Washington from California bring with them their revocable living trusts, because in California, probate is very expensive. It's fee based on the size of the estate, and you want to avoid the probate in California. How do you do that? You do that through a revocable living trust. In Washington, we have different rules, different laws. Our probates are much simpler and much less costly. But in addition to that, in Washington, if you want to protect assets for your surviving spouse against Medicaid spend down, then you should not have a revocable living trust. You should have a will that contains within it an asset protection supplemental needs trust. And that way, on your death, your assets will go to a trust that your will creates on your death through a probate for your spouse. And you might go, oh, probate, I thought I'm supposed to avoid that. Well, it depends on where you're at. Let's say you and your spouse have $1 million estate. On your death, everything is community. You want $500,000 to go to a trust that your will creates for your surviving spouse. That allows you to make sure your spouse will never become impoverished, because all of the assets in that trust are disregarded by the state Medicaid agency in the state of Washington. They don't count against your surviving spouse if they ever need the state to assist and pay for long-term care. So we know by a very simple planning tool, a will with an asset protection supplemental needs trust, we can protect half of the assets of this community. Whereas if we had a revocable living trust, we don't get that result. So that's like giving up $500,000 of asset protection because you didn't see an estate planning and elder law attorney in Washington when you moved here. So is it valid? Yes. Is it a good idea? Maybe, maybe not. And one other thing, getting back to the trust, if you recall, I was talking about how do you make sure that your kids, if you want them to inherit, do inherit if you're the first spouse to die. The supplemental needs trust that's in a will that I was talking about, it says, on my death, everything goes to my spouse in this trust for him. But it says on his death, it goes to, and you say where you want it to go, for example, to your kids. In other words, having a will with this kind of a trust, be it asset protection or a tax credit shelter or whatever it is, make sure that your wishes will be carried out on the second spouse's death as well. Excellent. Okay. Well, if there's any other questions, I'm not seeing them. So I'm happy to be able to give further guidance on this. We are at ELG Estate Planning, also known as Elder Law Group. We have an office in Spokane and Tri-Cities and in Seattle. Our phone number is 509-468-0551. And in the chat, you'll see our website is elgwa.com. Also, I do want to reach out that if you found this helpful, and thank you so much for the message in the question and answer there about learning from these webinars. I really appreciate it because it's really a goal of mine to demystify estate planning and elder law. I really want to make sure that people understand what their options are so that they can, go forth and take the action that's best for them. So thank you for that. And if you found it helpful, please give us a 5-star review on Google. We really appreciate that. We've got a lot of resources as well on our YouTube channel. So we appreciate you taking the time today to listen, and I wish you all the best. Thank you so much.